matter.
Fresh matter.
Fresh.
ಕೊಡಿ. ಫ್ರೆಶ್ ಮ್ಯಾಟ್ರ್ ಅದು ಹಳೆ ಮ್ಯಾಟ್ರ್.
2017.
Orders.
Orders.
ಏನ್ ಆರ್ಡರ್ಸ್?
Pass necessary orders.
ಆನ್ ವಾಟ್?
14%.
Division
bench ಇದು ಸಿಂಗಲ್ ನಿಮ್ಮಂದೆ ಸಿಂಗಲ್ ಬೆಂಚ್ ಇದು 14%.
ಆರ್ಡರ್ಸ್ ಅಂಡ್ ವಾಟ್? ಏನಕ್ಕೆ ಆರ್ಡರ್ಸ್? ಏನಕ್ಕೆ? ಸರ್ವಿಸ್ ಗೊತ್ತಾಯ್ತು. ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್ ಆದ್ರೆ ವಿಲ್ ಎಂಟರ್ಟೈನ್ ಮೆಮೊ. ಓಲ್ಡ್ ಮ್ಯಾಟರ್ ಆದ್ರೆ ಅರ್ಜೆನ್ಸಿ ಸ್ಟೇಟ್ ಮಾಡಿ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕ್ಬೇಕು, ಅರ್ಲಿ ಹಿಯರಿಂಗ್ ಇಲ್ಲಾರ ಬರೋದಿಲ್ಲ.
ಒಂದು ಅರ್ಲಿ ಹಿಯರಿಂಗ್ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿ, ಅರ್ಲಿ ಹಿಯರಿಂಗ್ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿ ಮೆಮೊ ಮೂವ್ ಮಾಡಿ, ಅರ್ಲಿ ಹಿಯರಿಂಗ್ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿ ಮೆಮೊ ಮೂವ್ ಮಾಡಿ. ಸಾಹೇಬ್ರಿಗೆ ಹೇಳಿ ಅರ್ಲಿ ಹಿಯರಿಂಗ್ ಅಪ್ಲಿಕೇಶನ್
ಅಪ್ಲಿಕೇಶನ್ ಹಾಕ್ಬೇಕು. ಅರ್ಜಿ ಏನಂತ ಜಲ್ದಿ ತೋಡನ್ ಆಮೇಲೆ ಮೆಮೊ
for posting. Earlier also I have given the memo for posting, but your lordship, the file is not
ಫ್ರೆಶ್ ಮ್ಯಾಟರ್
not fresh matter.
ಓಲ್ಡ್ ಮ್ಯಾಟರ್
Early hearing application ಹಾಕೊಂಡಿದ್ದೀನಿ. ಅದ್ರ ಮೇಲೆ
ಹಾಕಿದೀರಾ?
ಕಂಪ್ಲೈ
ಮಾಡಿದೀವಿ.
in this matter, this second time I am moving.
You have to say to post on IA on early hearing ಅಂತ ನೀವು ಹೇಳ್ಬೇಕು.
ಹೇಳಿ.
Yes. ಅದನ್ನ ಬರೆದು ಕೊಡಿ. Yes.
My lord, serial number 24, my lord. A time.
ಹೋಗ್ಲಿ ಕೊಡ್ರಿ, ಅವ್ರಿಗೊಂದು ಅದ್ರ ಡೇಟ್ ಕೊಡ್ರಿ.
Yes.
Let it be listed on 26th. 26ನೇ ತಾರೀಕು ಬರುತ್ತೆ ಕೇಸ್. ಆಯ್ತು.
My lord.
Yes.
Serial number 24, my lord.
Senior
around next week.
Serial number 24.
Time.
Other side ಇದಾರ ಇಲ್ಲಿ?
DYM code for respondent.
Yes, no objection. Serial number 24. At the request of learned counsel for the appellant, release this matter
Next week.
on 28th of November.
Serial number 28, my lord.
Ah.
I appearing for the petitioner. Can leave it Monday or Tuesday, my lord. Monday or Tuesday.
ಯಾಕ್ರಿ?
Senior is
Serial number 28. At the request of learned counsel for the petitioner, release this matter on 26th of November.
please no.
Orders serial number 1, Sivanand Patil.
So filed an application note for impleading proposed respond number 8 to 9.
You'll have to take steps.
If notice is notes ordered, we could pay.
ಆಗಿದೆಯಲ್ರಿ?
ಇಲ್ಲ, proposed response ಆಗಿಲ್ಲ.
ಹೌದು.
PF code, PF code.
You not
are 8, 9 and 10.
List 1.
That is in regards to deceased LR
Proposed respond number 8.
Yes, notes. I have filed an fresh application.
Issue notice to the proposed respondents on IA number 1 of 2024. Next para, a week's time is granted, at the request of learned counsel for the appellant, to take steps for service of notice on IAS number 2, 3 and 4 of 2018. Yes.
And 24, IA 1 of 24 is also notes. For
notice.
Notice, sir.
Please.
Notice. Yes.
Like.
Serial number 2, Jadege Kailas Singh.
Oh, we have gone. So Bangalore ಹೋಗಿದ್ದೆ my lord. ಅವ್ರು ಎಕ್ಸಾಮ್ ಮಾಡಿದ್ದಾರೆ, ರಿಪೋರ್ಟ್ ಹಾಕಿದ್ದಾರಂತ.
ರಿಪೋರ್ಟ್ ಕಳಿಸಿದ್ದಾರಂತ. A report from the Institute of Nephrourology has been received. Full stop. Copy of the report or communication dated 16/11/2024 shall be served on the learned counsels on both the sides. Release this matter on 28th of November. Please take a copy. We will hear.
First one, sir.
CL number 3, J. Augustine.
Process will be paid today during the course of the day.
Huh?
Process for fresh process.
Learned counsel for the appellant submits that the needful will be done during the course of the day. Full stop. If steps are taken, issue notice to respondents number 1 to 4.
CL number 4, Vijayalakshmi Melkundi.
Matter is called out. There is no representation for the appellant. A memo has been filed by the learned counsel for the appellant stating that she has sent notice to the appellant stating that she intends to retire from the matter. Full stop. The party has been requested to take back the files. Full stop. On this ground, learned counsel seeks to retire from the matter. Full stop. Next para. We do not accept the memo submitted by the learned counsel for the appellant. Full stop. She should ensure, the learned counsel should ensure that either there is alternative arrangement made for representation of the appellant or the appellant herself should be present before this court on the next date of hearing. Full stop. Release this matter on 9th of December.
CL number 5, Sachinam Mahajan.
My lord, may kindly post the matter by next week. We'll be
Huh?
taking the necessary steps.
Huh?
Respondent
Mic use ಮಾಡಿ sir.
Respondent 7 ಅವರು ಡೆತ್ ಆಗಿದೆ ಸರ್. So necessary steps ನಾವು ತಗೋತೇವೆ. Kindly post the matter by next week.
Kindly.
Post the matter by next week, my lord.
That observation was made during May 2023. You have not taken steps. So the appeal has abated as against respondent number 7. Berkeley. In the daily order dated 30/5/2023, it is noticed that the notice sent to respondent number 7 has returned with an endorsement that the respondent is dead. Full stop. At the request of the learned counsel for the appellant, the matter was adjourned by 3 weeks to enable the appellant to take steps to bring the legal representatives on record. Full stop. More than a year has elapsed after the order was passed and no steps have been taken, full stop. By effects of time, the appeal has abated as against respondent number 7. Yes.
6, Ramachandra K.
Ramchandra came also. Needful is done. PF is paid.
Huh?
PF is paid.
A learned counsel for the appellant submits that the needful has been done. Full stop. Office to verify and issue notice to the respondents.
Serial number 7, Ratna and Shivayogi Mat.
I appearing for the complaint in this case.
In this matter, Lordship directed the petitioner to implead the deputy commissioner.
Deputy Commissioner, my lord.
He did not find the any,
In the course, I court is permission.
only 8 murdered Lordship.
Despite specific directions being given by this court on 12/8/2024 that the complainant is required to implead the incumbent deputy commissioner, no such steps have been taken. Full stop. Nevertheless, at the request of learned counsel for the complainant, a week's time is granted to do the needful.
Please.
Yes.
Serial number 8, R.D. Nadagoda.
Weeks time, first steps, weeks times.
At the request of learned counsel for the complainant, a week's time is granted for
Unclaimed.
for taking steps for service of notice on accused respondents number 2 to 4. Your serial number 10 or 8. Non-compliance of office objection.
Serial number 8.
Steps to be taken, unclaimed. Serial number 8.
8. A week's time is granted to take fresh steps for service of notice on the respondent.
Serial number 9, Gururaj V. Asilkar.
Serial number 9.
Serial number 9,
I'm appearing for complainant.
Gururaj V. Asilkar.
I'm for petitioner, my lord.
Ah.
In this case, as per direction, Honorable Court, we have served the notice to the, before the principal family court, Kalaburagi, madam.
Yarge.
For responding notice, sir, madam. And summons was issued on last date of hearing.
Where is the
I am along with memo, I'm already filed. 2 sets I already filed. What the mercy say next?
learned counsel has filed a memo dated 8/11/2024 along with the hand summons issued to the respondent. Full stop. The respondent has received the hand summons before the
Principal family court, Kalaburagi.
principal judge, family court,
Family court.
Kalaburagi.
Kalaburagi.
Full stop. However, there is no representation for the respondent. So consequently, notice is held sufficiently served on the respondent. Yes.
CL number 10, Ganesh Nayak.
Appear for the respondent, my lord. We comply the, my lord, direction of the learned single judge.
Huh?
We complied the, my lord, direction of the learned single judge, my lord. We filed the affidavit, my lord, on 16/10/2024, my lord. Deputy Commissioner affidavit, my lord, along with the complaints order. For the learned single judge, my lord, para number 6, my lord.
Nomadic and the semi-nomadic class people committee, my lord, is the allotted for the 2 acres land for the, my lord, the residential purpose, my lord. The committee, my lord, cannot be properly, my lord, the beneficiary can be selected, my lord.
Committee is directed to consider.
Yes, my lord.
Consider our representation along with, my lord, the Panchanama was the conducted by the PDO. These beneficiaries are the, my lord, is the already the house are there, my lord, is the land is there, my lord.
Where is your representation?
My lord, is the page number, my lord, is 15, my lord. My lord, is the started, my lord, is the page number 9.
Alari, ee order ಆದ್ಮೇಲೆ
ಹೌದು.
you are permitted to give a representation to the committee.
Please, my lord, the page number 9, my lord, there is.
9.
Also. ಅಲೆಮಾರಿ ಮತ್ತು ಅರೆ ಅಲೆಮಾರಿ ಜನಾಂಗದ ನಿವೇಶಗಳ ಹಂಚಿಕೆಯಲ್ಲಿ ಅವ್ಯವಹಾರ ನಡೆದಿರುವ ಬಗ್ಗೆ ಸೂಕ್ತ ಪರಿಶೀಲನೆಗೋಸ್ಕರ ಮಾನ್ಯ ಜಿಲ್ಲಾ ಅಧಿಕಾರಿಗಳಿಗೂ ಮತ್ತು ಆಯಾ ಮುಖ್ಯ ಕಾರ್ಯನಿರ್ವಾಹಕ ಜಿಲ್ಲಾ ಪಂಚಾಯತ್ ಯಾದಗಿರಿ ಅವರಿಗೆ ಸಲ್ಲಿಸಲಾಗಿರುವ ಹಿಂದಿನ ಅವರ ಆದೇಶದ ಮೇರೆಗೆ ಗ್ರಾಮದ ಮುಖಂಡರು ಮತ್ತು ಪಂಚಾಯತ್ ಅಭಿವೃದ್ಧಿ ಅಧಿಕಾರಿಗಳು ಸೇರಿ ಫಲಾನುಭವಿಗಳ ಕುರಿತು ಸರಿಯಾದ ಪಂಚನಾಮ ವರದಿಯನ್ನು ಸಲ್ಲಿಸಿರುತ್ತೇವೆ. ಆದರೂ ಈಗ ಕೆಲವು ಮೇಲಧಿಕಾರಿಗಳಿಂದ ಒತ್ತಡದ ಅಕ್ರಮವಾಗಿ ಖಾಲಿ ನಿವೇಶದ ಹಂಚಿಕೆಯನ್ನು ಮಾಡಿರುತ್ತಾರೆ. ಆದ್ದರಿಂದ ಮಾನ್ಯ ನ್ಯಾಯಾಲಯ ಮೊರೆ ಹೋಗಿದ್ದು ಈ ನಿವೇಶನ ಹಂಚಿಕೆ ಮರುಪರಿಶೀಲಿಸಿ ನಿಜವಾದ ಫಲಾನುಭವಿಗಳಿಗೆ ನಿವೇಶನ ಹಂಚಿಕೆ ಮಾಡಬೇಕೆಂದು ತಮ್ಮಲ್ಲಿ ವಿನಂತಿಸಿಕೊಳ್ಳಲಾಗಿದೆ. As per the, my lord, is enclosure to the Panchanama. My lord, as the page number, my lord, the 24, my lord.
Yes, what is the complaints? The government advocate. What is the complaints?
Lord, kindly see, Lord, in my affidavit, my lord, Deputy Commissioner affidavit is filed, my lord. In there, my lord, page number 9, my lord.
What is this? Annexure R2.
R2 is the, my lord, proceedings of the Deputy Committee as, my lord. This is the proceedings of the committee, my lord.
ದಿನಾಂಕ 15/3/2024.
Yes, my lord. After passing the, my lord, order passed by the learned single judge, my lord, and, giving the representation by the complainant. In that, my lord, serial number 4, my lord. Karnataka Ucha ನ್ಯಾಯಾಲಯದ ಆದೇಶದಂತೆ ಮುಡುಗುಳು ಗ್ರಾಮದ ನಿವೇಶನ ಹಂಚಿಕೆ. This is starts, my lord. We discussed everything, my lord. And last para of that, my lord, last para of that is serial number 4, my lord. Karnataka Ucha ನ್ಯಾಯಾಲಯದ ಕಲಬುರಗಿ ನಿವೇಶನ ಪೀಠದ ಸೋನ್ಸೋ ಅವರ ಆದೇಶದ ಶ್ರೀ ವಾಸಣ್ಣ ತಂದೆ ಅಳ್ಳಪ್ಪ ನಾಯ್ಕೋಡಿ ಮುಡುಗುಳು ಇವರ ಮನವಿಯನ್ನು ಪರಿಗಣಿಸಿ 4 ವಾರಗಳ ಒಳಗಾಗಿ ಜಿಲ್ಲಾಧಿಕಾರಿಗಳ ಅಧ್ಯಕ್ಷತೆಯಲ್ಲಿ ಜಿಲ್ಲಾ ಅಲೆಮಾರಿ ಮತ್ತು ಅಲೆಮಾರಿ ಸಮಿತಿ ಸಭೆಯಲ್ಲಿ ತೀರ್ಮಾನಿಸಲು ನಿರ್ದೇಶನ ನೀಡಿ ಸದರಿಯವರ ಅರ್ಜಿಯನ್ನು ಮುಕ್ತಾಯಗೊಳಿಸಲಾಗಿರುತ್ತದೆ. ಕರ್ನಾಟಕ ಉಚ್ಚ ಪೀಠದ ನಿರ್ದೇಶನದಂತೆ ಶ್ರೀ ವಾಸಣ್ಣ ತಂದೆ ಅಳಪ್ಪ ಒಳಕೋಡಿ ಮುಡುಗುಳು ಇವರ ಮನವಿಯನ್ನು 2 ತಿಂಗಳ ಒಳಗಾಗಿ ಜಿಲ್ಲಾಧಿಕಾರಿಗಳು ಅಧ್ಯಕ್ಷರಲ್ಲಿ ಜಿಲ್ಲಾ ಅಲೆಮಾರಿ ಸಲಹಾ ಸಮಿತಿ ಸಭೆಯಲ್ಲಿ ಮಂಡಿಸಬೇಕಾಗಿರುತ್ತದೆ ಎಂದು ಸಭೆಗೆ ವಿವರಿಸಿದರು. ಮಾನ್ಯ ಜಿಲ್ಲಾಧಿಕಾರಿಗಳು ಯಾದಗಿರಿಯವರು ದಿನಾಂಕ 1-2-2022 ಟಿಪ್ಪಣಿ ನಿರ್ದೇಶನದಲ್ಲಿ 59 ಫಲಾನುಭವಿಗಳು 13 ಫಲಾನುಭವಿಗಳು ಹೊರತುಪಡಿಸಿ 46 ಅರ್ಹ ಫಲಾನುಭವಿಗಳಿಗೆ ನಿವೇಶನ ಹಂಚಿಕೆ ಮಾಡಲಾಗಿರುತ್ತದೆ ಎಂದು ಶಿವಣ್ಣ ತಂದೆ ಅಳ್ಳಪ್ಪ ನಾಡ್ಪುಡಿಯವರಿಗೆ ಹಿಂಬರ ನೀಡಲು ಉಪನಿರ್ದೇಶಕ ಹಿಂದುಳಿದ ವರ್ಗಗಳಿಗೆ ಕಲ್ಯಾಣ ಯಾದಗಿರಿ ಸೂಚಿಸಲಾಗಿದೆ. Thereafter, my lord, he issued the endorsement, my lord, that is also served to the complainant. That is, my lord, Annexure R. That is page number 31, my lord.
ಕೊಡ್ರಿ ಪಂಚಾಯತ್ ರಾಜ್ ಕೊಡ್ರಿ. What are the provisions governing allotment of sites?
That is, my lord, in the proceedings itself, my lord, it is discussed, my lord.
ಏನ್ ಪ್ರಾವಿಷನ್ ಏನು ಡಿಸ್ಕಸ್ ಮಾಡಿಲ್ಲ ಅಲ್ಲಿ.
Please, my lord. I will make submission, my lord. You will also pay it on Monday.
Ganesh Naik,
Please, man.
it is for you to say what are the provisions, what is that procedure they are required to follow. ಸುಮ್ಮನೆ ಒಂದು ರೆಪ್ರೆಸೆಂಟೇಷನ್ ಕೊಟ್ರೆ ಅವರು ಇದೇ ತರ ಎಂಡೋರ್ಸ್ಮೆಂಟ್ ಕೊಡ್ತಾರೆ.
Please, man.
Nothing will happen.
My lord, the nomadic and my lord, semi-nomadic, my lord, is the
You
key
had asked
class.
for
Oh.
consideration of your
Please.
representation.
Please.
They have considered.
My lord,
They have
as
passed.
per the key own, my lord, the PDO, my lord, is the key conducting the Panchanama, my lord. My petition, my lord, the page number 24, my lord.
ಹೇಳ್ತಾ ಇರೋದು which provision? What procedure are you talking of?
My lord, as per the key, my lord,
Without
the
even
key-
referring to the provisions, you simply make a representation
But my lord, has the key.
and directions you are issued, consider.
But even those, my lord, the 50,
ಮಾಡಿದ್ದಾರೆ, consider ಮಾಡಿದ್ದಾರೆ, ಕೊಟ್ಟಿದ್ದಾರೆ.
my lord, the 57, my lord, the beneficiary,
Which is the
13
provision, sir? Please show.
Lord, the- I find
Without
the-
reference to provisions,
Please,
these kind of representations are made. It's a futile exercise,
I filed the detail
waste
objection.
of time,
My lord, I filed the detail
Waste of the
objection
time of
along
the
with
court,
the, my lord, the.
waste of the time of the
Please.
committee which is reconstituted for your purpose. ಬರ್ಕೊಳ್ಳಿ. Learned government advocate.
I
has
filed, my
filed-
lord, the detail objection regarding that, my lord, on base of the key
ಇಲ್ಲಿ
committee.
ಅಬ್ಜೆಕ್ಷನ್ ಫೈಲ್ ಮಾಡ್ರಿ, ಏನ್ರಿ ಪ್ರಯೋಜನ? What was the direction given by the learned single judge?
But my lord, has
Consider
per-
your representation.
Please,
They
my
have
lord.
considered.
My lord,
ಮುಗೀತಲ್ಲಿ.
my lord, I have one submission, my lord, page number 24, my lord, has per the conducting of the Panchanama by the PDO, my lord, he is the
This
key
is
one
contempt
department.
court. We are only required to consider whether there is compliance or not. ಅಷ್ಟೇ.
My lord, the only the
Arbitrage-
beneficiary of the, my lord, the pay, my lord, the 59 members.
They have to
regarding-
lay the base while filing the and
Please.
drafting the writ petition.
My lord, I filed, my lord, the entire the writ petition, my lord, on base of that, my lord, the document.
ತೋರಿಸಿ, please show the provision.
My lord, as per the key committee can be key allotted, my lord, the poor person, my lord.
ಅದರೇ ಹೇಳ್ತಾ ಇರೋದು. There is no reference to any provision.
Please, my lord, there is the key, no. But the provision, my lord, the committee, nally, my lord, has the key allotted to, my lord, the poor person, my lord, the poor
Therefore,
families, my lord, has the allotted to the.
The
my lord, the
next
site.
question that would arise is,
Please, my lord.
if such an order is passed, is there no appeal provision in the statute?
House.
ಮತ್ತೆ? Where is the question of considering your representation?
But my lord, as per the committee itself, he has the, my lord, is
But
blankly
government
to the
advocate
consider, my lord, there is the
Has
key.
filed an affidavit of complaints at the hands of the Deputy Commissioner, Yadgir, who is also the chairman of the nomadic and semi-nomadic class people.
Sorry, my lord,
Committee.
one submission.
Full stop. Learned government advocate submits that the directions issued by the learned single judge was permitting the complainant herein to give a representation to the committee. And the committee was directed to consider the same in accordance with law. Full stop. In the affidavit, the deputy commissioner, who is the chairman of the committee, has stated that in terms of the directions issued by this court, the complainant herein gave one more representation on 29/1/2024, and the committee was
15/3/2024. Page number 8.
rescheduled and met on 15/3/2024. Full stop. On 15/3/2024, the grievance of the petitioner was considered, and it is stated that out of the 59 applicants, 46 were found to be eligible, and accordingly, the allotment of sites have been made.
The 46 members in list was not pronounced, my lord.
Next para. Learned counsel for the complainant, however, seeks to contend that the committee has not followed the due procedure. Full stop. In our considered opinion, these questions cannot be gone into in a contempt jurisdiction. Full stop. It was for the complainant to make out a case before filing the writ petition. Full stop. Moreover, we find that if the grievance of the petitioner is that the due procedure were not followed, then it was the duty of the complainant to point out as to which is the procedure and say as to whether there is an appeal provision or not. Full stop. If there is an appeal provision, then a writ petition would not lie, since there would be an alternative efficacious remedy available for the petitioner. Full stop. Next para. For the reasons stated above, we are satisfied that the committee was reconstituted and considered the representation given by the petitioner and have issued an endorsement in that regard. Stop. Next para. Consequently, we proceed to close the contempt petition.
Great.
Yes.
number 11, Sharan Basappa, M. Patil.
Lord, in this matter also, my lord, we are appear for the respondent, my lord.
Appearing for complainant, my lord, 2 days time to pay the process fee, my lord.
But kindly see the, my lord, para number 3, my lord. Para number
Copy
3.
ಕೊಟ್ಟಿದ್ದೀರೇನ್ರಿ ಅವ್ರಿಗೆ?
Copy served.
ಮತ್ತೆ
For
ಇನ್ನೇನ್
the,
ಸ್ಟೆಪ್ಸ್ ಇವಾಗ?
ಅಲ್ಲ, ಅಲ್ಲ.
ಕಂಪ್ಲೇಂಟ್ಸ್ ಆಗಿದೆ ಅಂತ ಹೇಳ್ತಾರೆ.
no, my lord, it is not compliant.
That's why, my
That is the submission of the government advocate.
para number 3 of the order of the learned single judge, my lord. It is grievance of the petitioner that the land belonging to the petitioner has been utilized by the respondent authorities for construction of the bridge cum barrage without initiating acquisition proceedings. In this regard, petitioner are permitted to make representation to the competent authority seeking redressal of their grievance, and if such representation is made within 2 weeks from the date of the receipt of the scheduled copy of the order, then respondent number 1 to 3 herein shall consider the same within a period of so and so. Kindly see, my lord, we filed the update, my lord. In pursuance of the order passed by the Sun Court, yesterday I filed the update, my lord, that is along with lectures. That is, my lord, minor irrigation, my lord, requested the deputy commissioner to comply the direction of the honorable court, my lord. Then, my lord, deputy commissioner in turn directed to the SLO to make the, my lord, send the proposal. That is, total amount is, my lord, 43,50,000 rupees is estimated to the extent of 3 acres 25 quintas. That was, my lord, now we requested the government to release that amount. So, as per the direction of the law, we proceeded to initiating the acquisition proceeding. Annexure R5 is the, my lord, amount. If that amount is released, my lord, then we will proceed with the.
ಅಲ್ರಿ ಅಕ್ವೈರ್ ಆಗಿಲ್ಲ ಅಂತ ಹೇಳ್ತಾರಲ್ರಿ,
Yes, my lord, that's why, my lord, this is the, my lord, amount, my lord, we have to seek for the acquisition proceedings. That's why, my lord, we are seeking for the, my lord, this amount has to be deposited.
How it will come without acquisition?
No, not, my lord. First, they have to deposit the amount first initially, my lord. Thereafter, my lord, SLO issue the notification.
Already notification issue bedvenri.
After the depositing this amount, my lord. But
Huh?
beneficiary is the minor irrigation, my
So
lord.
you have taken steps.
Yes, my lord, we've taken the steps, my lord. If that amount is deposited, we will initiate the, my lord. That is the affidavit, my lord.
No, you have not stated that the government has been intimated and it has given its consent to go ahead and notification in that regard will be issued.
Allah, that's why,
You are simply talking of the amount.
yes,
How
that,
can you release it without acquisition?
no, that's why, Madi, that if the amount is deposited, Madi, that's a kindly say, madam.
Where have you stated
That is, my lord.
that acquisition proceedings will be?
Or
Where
that
have you stated?
para 9, my lord, para 9 of the affidavit, my lord. It is
Will
submitted
be
that as per
deposited
the,
before the special land acquisition officer for initiating land acquisition proceedings under
Yes.
section 11(1).
Lord,
Proceeding ಮಾಡಕ್ಕೆ ದುಡ್ಡು ಬೇಕು.
Lord, kindly say, my lord, kindly para 9, my lord, para 9.
Initiate ಮಾಡಕ್ಕೆ 43 ಲಕ್ಷ ಇರುತ್ತೆ ಸರ್.
11-1, we have to insert the acquisition as per section.
Reverse procedure avoid.
Allah, 11-1, para 9 of the affidavit, my lord, for a moment.
Yes, we have read it.
It is submitted that as per the request of the chief engineer, the amount is not yet released by the.
Land acquisition act ಕೊಡ್ರಿ.
If the,
ಹೊಸ ತಾನೆ ಇವಾಗ. This will be a new
Allah, we are.
land acquisition act ಬರೋದಿಲ್ಲ.
Allah, we used the long back, my lord, this one, my lord. That's why, my 11-1 is applied.
Is not acceptable. What you are required to do is now.
But
There is no old notification issued.
that's true, my lord.
So
Here,
how can you say old act will apply?
that is the, my lord, direction to initiate, my lord. They are not, my lord, Laro single judge not
Perfect.
specifically stated that, my lord, whether we have to insert old act or new act, my lord. That is the problem.
Old act ಅಲ್ಲಿ ಹೆಂಗ್ರಿ ಆಗುತ್ತೆ when land is not notified for acquisition.
Taken the possession long back, my lord. Once you utilize that land, my lord.
Ena?
Once, my lord, we utilize that land, my lord. 11-1 is applicable.
How?
Now, my lord, we don't know, my lord, what provision, my lord, we are going to issue the notification, my lord. Then if that amount is received, my lord, then we will insert the acquisition. He can make the objection also, my lord. He can give the representation whether he is entitled under the new act or old act.
No, see, we are not concerned about your request to release the amount. What we are concerned is that the process for initiation of acquisition
Yes, but that is, my lord.
has not been contemplated. Nothing is said. No permission of the state government is taken.
No, kindly say, in the para 9 itself, my lord, before the land acquisition after, for initiating the land acquisition proceedings, that one, my lord, we take on that.
Why are you asking for the amount to be deposited then?
Because, my lord, first, my lord, beneficiary has to deposit amount.
Who has to determine and how?
No, that is initially, my lord,
It is the special land acquisition officer who has to determine.
That, no, my lord.
Who has determined this amount?
But SLO is requested, my lord, kindly say, my lord, annexure, my lord, kindly say, my lord. That is, my lord, annexure R3, my lord. Annexure R3. Page number 7, my lord. This is the special land acquisition officer intimated to the beneficiary to deposit this amount, my lord. ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಕಲಬುರಗಿ ಜಿಲ್ಲೆಯ ಕಲಬುರಗಿ ತಾಲೂಕಿನ ಸೋನ್ಸೋ ಜಮೀನುಗಳು ಬ್ರಿಡ್ಜ್ ಕಮ್ ಬ್ಯಾರೇಜ್.
ಆಯ್ತು ಮಾಡಿ. ನಮ್ಗೇನ್ ತೊಂದ್ರೆ ಇಲ್ಲ. ನೀವು ಡೆಪಾಸಿಟ್ ಮಾಡಿಸ್ಕೊಳ್ಳಂಗಿದ್ರೆ ಮಾಡಿಸ್ಕೊಳ್ಳಿ. ಬಟ್ ವಿ ಆರ್ ಕನ್ಸರ್ನ್ ಮೋರ್ ವಿತ್ ದಿ ಇಶ್ಯೂಯನ್ಸ್ ಆಫ್ ದಿ ನೋಟಿಫಿಕೇಶನ್.
ಇದು ಬಂದ ತಕ್ಷಣ
and arriving at the award.
ಅಲ್ಲ ಫಸ್ಟ್ ಮಲಡ್ ಇನಿಷಿಯಲಿ ಮಲಡ್ ದಟ್ ವಿ ಪಾಸ್ ದಿ ಅವಾರ್ಡ್
ಮಲಡ್ ಬೇಕಾದ್ರೆ ಮಾಡ್ಕೊಳ್ಳಿ. If you think this is the procedure, you please go ahead.
Yes, mallard. That's why there is a direction to insert the proceedings, mallard.
This is not enough. This will not be enough.
Proceedings, mallard.
ಏನು ಹೇಳಿದೆ? Learned government advocate submits that a compliance affidavit of the executive engineer, minor irrigation department, GWD division, Kalaburagi has been filed on 21/11/2024. Full stop. Learned counsel for the complainant raises an objection that this procedure will not comply with the directions issued by the learned single judge. Full stop. It is submitted that the grievance of the complainant is that a portion of his land has been utilized. A portion of their lands have been utilized for construction of bridge cum barrage in Kavalagi bracket B village, and therefore the petitioners are seeking initiation of acquisition proceedings, determination of compensation, and thereafter payment of the award. Full stop. Learned counsel submits that in terms of the affidavit filed by the executive engineer, it appears that the special land acquisition officer has directed the beneficiary to deposit a sum of rupees 43,50,000 towards payment of compensation for 3 acres and 25 guntas of land. Full stop. However, nothing is stated in the affidavit regarding the request made to the state government for issuance of notification of acquisition. Full stop. Next para. The learned counsel for the complainant is right in the submission that merely because the special land acquisition officer has directed the beneficiary to deposit a certain amount, that would not be in compliance of the directions issued by the learned single judge. Full stop. Next para. Learned government advocate is therefore directed to secure instructions as to whether communication has been made to the state government requesting issuance of notification of acquisition. Full stop. Next para. Release this matter on 5th of December.
My lords, one submission, my lords, regarding reissue of notice. Reissue of
Notice.
Yes, my lord.
Accused number 2.
2 to 4.
2 to 4. ಏನಾಯ್ತು?
Notice reissue ಅಂತ ಬಂದಿದೆ. So I may take, I may pay process fee in 2 days, my lords. 2 days.
Already last time we are directed.
Yes, my lord, I have paid.
Respond number 2 to 4.
I have paid process and I have complied the order, my lord, but today also it has listed for reissue to in respect of respond number 2 to 4, my lord.
Yavaga, when did you pay?
On, my lords, on 7th, my lord, 7th November, my lords. 7th.
ಓ ಅದ ಅದು ನನಗೆ ಹೋಗಿರ್ಲಿಲ್ಲ, ನನ್ನ ಲಿಸ್ಟ್ ಆಗಬೇಕಾಗಿತ್ತು.
Yes, my lord, yesterday.
If steps have been taken by the complainants, issue notice to response number 2 to 4.
Yes.
Returnable by 5th of December.
In 2 days, I will pay the.
Yes.
CL number 12, Harshavardhan R. Mali Patil.
Your Lordship, the council submission is with regarding to, Your Lordship, why the respond number 1 is made as a party. Your Lordship, learned single judge has passed an order directing the Deputy Director of Public Instructions to look into the matter, Your Lordship. And after the judgment was passed, Your Lordship, the complainants gave a representation to the respond number 1, who was a Deputy Director of Public Instructions at that time. And later on, after 1 month, Your Lordship, he was suspended, Your Lordship. So that is why he has been made as a party in this contempt, Your Lordship. And subsequently, a new officer was appointed, and for them also a representation was made, Your Lordship.
Respond number 2. Deputy Director of Public Instructions, Vijayapura.
Please, Lordship. He was the subsequent officer.
Was the,
Which was who was
he was the
appointed.
incumbent officer as on the date when the order was passed.
No, respond number 1, Your Lordship.
Respond number 1.
Please, Lordship.
He was the officer.
He was the officer.
Huh?
Please, Lordship. The judgment of the learned single judge is passed in the month of August 24, Lordship. And respond number 1 was suspended in the month of October 24, Lordship. So he was there. Please, Lordship.
So he was the incumbent officer.
Please, Lordship.
Office objection. Regarding respond number 1, implement of respond number 1 is overruled. Next para. Learned government advocate takes notice for respond number 3. Issue learned counsel for the complainant is directed to serve copies of the petition along with annexures in the learned government advocate. Full stop. Next para. Issue notice to response number 1 and 2, returnable by 5th of December.
Obliged.
Please.
Seal number 13, Ganesh Nayak.
Acceptance of note below cost title. Respond number 1 is formal party. As they were party in the writ petition. Sorry. That can be ignored.
Please, my lord. There is rowdy seater, my lord, is the direction to the authority, my lord, is there.
Huh?
Rowdy seater is the key involved, my lord. Already the case was the key acquit, my lord.
Huh.
The subsequent, my lord, is the approach before this court, my lord, has the key direction to the, my lord, is the consider the representation. Along with, my lord, the my lord, the page 12 of the, my lord, the operating period. The representation given by the writ petitioners shall be considered by the appropriate authority within a period of 3 months in the appropriate order passed and file the compliance report.
Already, ನೀವೇನಾದ್ರು ಹೇಳೋದ್ ಬೇಡವೇನ್ರಿ? Who is the competent authority to consider ಅಂದ್ಬಿಟ್ಟು ಎಲ್ಲಾರ್ಗೂ representation ಕೊಟ್ಬಿಡ್ತೀರಾ?
My lord, is the
What is the use?
rowdy seater, my lord, is the key, including the respond, my lord, is the
No, who is the competent authority to consider your representation?
My lord,
Remove your name from the rowdy sheeters list.
my lord, the 5th respondent, my lord.
Then why did you not say so before the learned single judge? Huh?
We are the giving the
ಎಲ್ಲಾರ್ಗೂ ಸೇರಿಸಿ representation starting from the principal secretary and to till the inspector. Accordingly, directions are given. Appropriate authority. Office objections are overruled. Learned government advocate takes notice for respond number 1. Learned counsel for the complainants is directed to serve copies of the petition along with annexures in the learned government advocate. Next para, issue notice to response number 25. Deputy Commissioner Ingri ಬರ್ತಾರೆ ಇದರಲ್ಲಿ.
My lord, is the deputy commissioner, my lord, is the district, my lord, is the under the, my lord, the rowdy seater is the key involvement ಅವ್ರಿಗೆ ಬರುತ್ತೆ
Huh?
Deputy commissioner ಮಾಡ್ತಾರೆ ಸ್ವಾಮಿ.
Who is
Commissioner,
the competent authority to consider your representation to remove the name from the
The commissioner and the deputy commissioner.
It is the SP
SP my lord,
or
the
the
city,
commissioner of police.
city commissioner ಬರ್ತಾರೆ sir.
ಹಾ ಮತ್ತೆ
ಇದಕ್ಕೆ
ಡೆಪ್ಟಿ ಕಮಿಷನರ್ ಯಾಕೆ ಪಾರ್ಟಿ ಮಾಡ್ತೀರಾ ಮತ್ತೆ? Issue notice to respond number 3. And 5. Notice to response number 3 and 5 returnable by 5th of December. Notice to respond number 2 and 4 is dispensed with. Yes.
14, liyakat Farid Ustad.
For the petitioner, my lord, the office objection is with regard to filing of objection by the respondents. The objections were filed by the government advocate before KAT on behalf of all respondents, my lordship may kindly. That office objection over, maybe over.
Statement of objections of response number
Our,
and 4
our
to be filed.
my lord, they have, what objections were filed before KAT was on behalf of all respondents.
Huh?
Behalf of respondents ಅಂತ ಅವರು objection ಹಾಕಿದ್ದಾರೆ. ಒಂದೇ objection ಹಾಕಿದ್ದಾರೆ KAT ಮುಂದೆ. ಅವರು ಸ್ಪೆಸಿಫಿಕಲಿ ಬರ್ದಿಲ್ಲ 1, 2, 3
Office
ಅಂತ.
objection regarding production of statement of objections
I have filed the
filed at the hands of respond number 3 and 4 is overruled.
Hold.
Comma since statement of objections were filed on behalf of all the
all
respondents. Yes.
Lord, the matter is, the question of law is, my lord, whether inquiry under Rule 11 can be converted into Rule 13 of KCSR. Because the article of charges were issued under Rule 11, in page 67 may kindly be seen, my lord. And thereafter joint inquiry was conducted against all DGOs. There were about 26 DGOs, my lord. Among some of the DGOs, my lord, have filed application before the KAT Dharwad, my lord. The KAT bench at Dharwad, my lord, has
There is no application for stay.
ಇದೆ.
Huh?
Yes, my lord. Writ petition is the line.
Interim prayer.
Yes, my lord. I was enjoying the benefit of interim order throughout the application. My lord.
Where is the order?
My lord, order is page. It start from page 13, my lord.
You are not furnished copy of the interim order if it was passed.
My lord, I was not furnished, but in my interim prayer, my lord, I have mentioned, my lord, on which date, my lord, it has been passed. The interim order is
Grounds for interim prayer. In grounds for interim prayer. Huh?
Yes, sir.
Please read.
Honorable KSCT, wide its order dated 31/5/2023, pleased to grant the interim order of stay of implemented order dated 6/12/2023 by Annexure A8. The said interim order was continued until disposal of the above said application. Thereafter, hearing both the parties, the Honorable KSCT, wide its order dated 30/9/2024, pleased to reject the above application without considering the material available. The interim order is there, my lordship. Because he has been removed from the service, my lord. The relevant para, my lord, is para number 32, my lord, in page 39.
Already, you are taken a stand that your signature is forged by someone else. How can it be done in the official books? And it will not come to your notice at all?
Lord, that is the
That is
contention.
your stand.
Lord, this is the case, my lord, where lordship make it requires consideration, my lord, kindly.
Consider matter. Representation ಕೊಡಿ. ಈ ಮತ್ತೆ ಇದ್ರಲ್ಲ ಫೈನಲ್ ನೋಡ್ ವಜಾ ಮಾಡಿಲ್ಲ.
He has removed from service, my lord. He is removed from service, my lord. Matter requires consideration, but till then, order may be granted.
Applicants are directed.
This final order is in page number 51.
Because other DJs, in respect of other DJs, my lord, matter was allowed by the tribunal, my lord, Harvard bench. And
This was not brought to the notice of the.
yes. In
tribunal?
para number 30,
If it is considered, then what can we say?
para number 32.
If the main allegation is against you,
No, my lord.
and therefore the others have been.
No, that has been passed on the ground that whether joint inquiry can be, individual inquiry can be converted into joint inquiry. In this regard, on that sole ground, my lord, the matter was allowed.
So therefore, what is the reasoning here?
Here, it doesn't,
Paragraph
para number 32,
32.
in page 39. The next contention conversed by the learned counsel for the applicant is that inquiry conducted by the inquiry officer and the disciplinary authorities against the provisions of KCSR. However, it is pertinent to note that the inquiry has been conducted in accordance with Karnataka civil service rules and not as per provisions of KCSR, and therefore this contention is misconstrued. The learned counsel for the applicant has relied upon the stay order granted by the coordinate bench KCT Belgaum, and also he has filed a memo on 23/4/2000 stating that the applicant's file was similarly placed employees in application number so and so have been allowed, and the current applicant is also covered by the said judgment. The said order has been examined by us, and the applicant have been partly allowed and remitted back to the respondent with the direction to conduct a joint inquiry as per Rule 13. Therefore, we are of the considered opinion that the order rendered by KCT Belgaum bench which not be of any assistance, because it has not taken into consideration at all.
When the direction is that you'll have to hold a joint inquiry, including this person.
Yes, ma'am.
Perfect. learned government advocate takes notice for all the respondents. Learned counsel for the petitioner is directed to serve copies of the writ petition along with annexures on the learned government advocate. Full stop. Next paragraph. Learned counsel for the petitioner submits that although it was brought to the notice of the tribunal at Belagavi that in respect of the co-delinquent employees, this court, ಅಲ್ಲಿ tribunal ಅಲ್ಲಿ
Tribunal, they have relied upon the judgments of M.A. Mahadevaya versus state and Indra Kumar versus state.
ಒಂದ್ ನಿಮಿಷ ಏನ್ ಹೇಳಿದೆ?
Also, but the petition submits that although it was brought to the notice of the tribunal at Belagavi, that in respect of
To the notice of the tribunal that ಇವಾಗ ಓದಿ
in respect of co-delinquent employees, this court.
that in respect of co-delinquent employees, the Karnataka State Administrative Tribunal, sitting at Belagavi, in application number 10219 of 2023 and connected matters. Held that a joint inquiry was required to be held in terms of Rule 13 of the KCS bracket CCA rules for 1957, and accordingly the impugned order dated 11/4/2023 was set aside. Nevertheless, the tribunal did not accept such a contention. Full stop. Learned counsel submits that if the requirement of the law and the procedure is that in respect of an allegation made against several of the employees and under such circumstances, the inquiry has to be a joint inquiry under Rule 13, it cannot be directed that the directions issued by the coordinate bench will not apply to the applicant. Full stop. If the requirement of the rule is that a joint inquiry has to be held, it would mean that the orders passed based on different inquiries held in terms of Rule 11, 11 cannot be sustained. Stop. Next paragraph. Consequently, there should be an ad interim order of stay.
Of annexure A8.
ಯಾವ್ದು ಸ್ಟೇ ಕೇಳ್ತಾ ಇದ್ರಿ? You are asking of the stay of the
yes,
original order.
Because that is the original order, my lord, which has been, now the application is dismissed. I cannot seek stay of that order.
Impugned order dated 6/12/2022 at annexure A8. Till the next date of hearing.
Please.
Number 15, additional government advocate.
My lord, state has preferred appeal against first additional district.
Respondent.
There is delay of 40 days. in filing recalling application.
Sorry for interruption, my lord. This matter was dismissed for default, my lord, before ARG, my lord. And we made the application for recalling that order, my lord. Your lordship, keep it pending the IA, my lord, we permitted to comply the office objection.
Pending consideration of IA number 1 of 2023. 1 and 2 of 2023. The appellants are permitted to comply with the office objections raised on the appeal.
Please.
CL number 16, Uday P. Omuntikar. CL number 16,
I'm for respondent.
Uday P. Omuntikar.
My lord, I have for appellant. My lord, appeal filed by the insurance company, my lord, 88 days is delay in filing the above appeal.
Ah.
Lord, challenging liability. And the ground that, my lord, the driver of the vehicle, my lord, he was not holding a driving license. The vehicle is, my lord, truck, my lord. That is heavy goods vehicle is there. He was
Decision.
ಅಲ್ಲ ಅದು
Latest decision.
ಅಲ್ಲಿ ಲೇಟೆಸ್ಟ್ ಡಿಸಿಷನ್ ಮೈ ಲಾರ್ಡ್ ಎಂಡೋಸ್ಮೆಂಟ್ ಇಲ್ಲ ಅಂತ ಹೇಳಿದ ಅದಕ್ಕೆ ಮುಕುಂದ್ ದೇವ ಕನ್ಫರ್ಮ್ ಮಾಡಿದ್ದಾರೆ ಬಟ್ ಇಲ್ಲಿ ಹೆವಿ ಗುಡ್ಸ್ ಇದೆ ಇವರು ಎಂಡೋಸ್ಮೆಂಟ್ ಇಸ್ ನೆಸೆಸರಿ
Laden weight is more than
ಮೈ ಲಾರ್ಡ್ 7,500.
correct.
But here, maybe his submission is incorrect. They have themselves have produced the exhibit R2. I will pass on with Malad. R2, wherein Malad it clearly shows that Malad he has obtained the DL in the year 2016. Passport, I will mark it. It will Malad up to 3 years irutte.
ಅವ್ರಿಗೆ ಒಂದ್ಸರಿ ತೋರಿಸ್ಬಿಡಿ. ಅವ್ರಿಗೆ ಒಂದ್ಸರಿ ತೋರಿಸ್ಬಿಡ್ರಿ.
ಅವ್ರು ಹೇಳಿಲ್ಲ. He was in a DL extract history. Add a cover to effective to DL 2000 transport 16/10/2016. So date of the exempt is Malad. Date of the effective start add on extra add on. Earlier he was having a DL. Thereafter LMV. Thereafter transport endorsement was given. So even though Malad, even though pain recovery antu idde ide. Pain recovery. I am entitled any time for Malad the amount from any one of the actual there is any DL is there. But apart from that, pain recovery idde ide.
ಅದು ಹೋಯ್ತು ಅಂತ ನೆನ್ನೆ ಯಾರೋ ಸಬ್ಮಿಷನ್ ಮಾಡ್ತಾ ಇದ್ರು.
ಅಲ್ಲ, that is ರಂಭಾದೇವಿ. That point is that is maybe ಅವ್ರು ಯಾವ ಪಾಯಿಂಟ್ ಅಲ್ಲಿ ಮಾಡಿದಾರೋ. Earlier Mukund Devagan was holds that who is the person having a DL of LMB, he did not having a transport endorsement in respect of the vehicle below the unladen weight 7,500. That was challenged by the insurance companies before constitutional bench by undertaking that pending cases will not any effect. The matter is going on, Malad. Ramba Devi holds that Mukund Devan judgment is holds good. So it is confirmed in the constitutional bench that in respect of LMB license, persons who is having not required for the transport endorsement. But here it is in a transport vehicle, heavy vehicle, though he was in having a DL. Is a DL ide ನಮ್ಮ ಹತ್ರ. ಅವರು ಐ ಥಿಂಕ್ ಆ ಒಂದು ಯಾವುದೋ ಒಂದು ಅಬ್ಸರ್ವೇಷನ್ ಇದ್ರದಾಗಿ ನೋಡಿ ಇದು ಮಾಡಿದ್ದಾರೆ. ಬಟ್ R2 ಇಫ್ ಮಾಡಸ್ ಪರ್ಮಿಟ್ ಐ ವಿಲ್ ಪಾಸ್ ಆನ್ ದಿ ಎಕ್ಸಿಬಿಟ್ R2.
That has been examined. That has been examined by the tribunal.
ಹೌದು, ಎಕ್ಸಾಮಿನ್ ಮಾಡಿದ್ದಾರೆ ಸರ್.
What is the finding?
Finding is that Malad,
that is finding Malad in ink page number 23. Malad in internal judgment page number 16. Malad that is middle line Malad wherein Malad he has examined the administrative officer namely Baswaraj Malshetti RW1 during the course of chief examination. RW1 has got marked exhibit R2 the extract driving license of driving offending vehicle. According to the RW1, on the date of accident the driver license of driving offending vehicle was not renewed, one for driving transport vehicle. But on record, the copy of DL driver offending vehicle shows he obtained DL for driving transport vehicle on 17/10/2013 and valid till 4/9/2032. That is the 20 years is there. Insofar concern, Malad, light motor vehicle. Here specific endorsement is necessary.
13
ಆ ಸ್ಪೆಸಿಫಿಕ್ ಎಂಡೋರ್ಸ್ಮೆಂಟ್ ಇದೆಯಲ್ಲ ಅಲ್ಲಿ.
ಇಲ್ಲ.
He is pointing out.
ಇದೆ ಸ್ವಾಮಿ.
That was he was showing that Malad ಅದು ಲೈಸೆನ್ಸ್ 13 ತಗೊಂಡು 16 ಎಂಡ್ ಆಗುತ್ತೆ.
ಆಕ್ಸಿಡೆಂಟ್ ಆಗಿದ್ದು 2018 ಅಲ್ಲಿ ಆಗಿದೆ. ಆ ಮೀನ್ ಆ period ಅಲ್ಲಿ ಇಲ್ಲ. ಅಲ್ಲ ಇದು ಆ ಬರಲ್ವಂತೆ, ಆ ಪ್ರಶ್ನೆ ಬರಲ್ವಂತ ಇದ್ರೆ. ಆ ಪ್ರಶ್ನೆ ಬರೋದಿಲ್ಲ. Please give that, please.
Please, alpha.
This is more than that weight. So that issue will not arise here.
ಇಲ್ಲ
It
ಪೆನ್
will
ಇದು
accept
ಮಾಡ್ಕೊಳ್ಳಿ. ಪೆನ್ ಇದು ಮಾಡ್ಕೊಳ್ಳಿ. ಅವ್ರು 16 ಮಾರ್ಕ್ಸ್ ತಗೊಂಡಿದ್ದಾರೆ. 16 ಮಾರ್ಕ್ಸ್ ತಗೊಂಡಿದ್ದಾರೆ. It will cover for another 3 years up to 19. And ಅದ್ರ ಮೇಲ್ಗಡೆನೂ ಮತ್ತೆ ಅಲ್ಲಿ ತಗೊಂಡಿದೆ. ಆ ಪೆನ್ನಿಂದ ಮಾರ್ಕ್ ಮಾಡಿದಿಲ್ಲ ಸ್ವಾಮಿ ಮುಂದ್ಗಡೆ. ಮೇಲೆ ಟ್ರಾನ್ಸ್ಪೋರ್ಟ್ ಅಂತ ಬಂದಿದೆ ಮೇಲ್ಗಡೆ ಹೆಡ್ಡಿಂಗ್. ಆ ಕಾಲಮ್ ಮೇಲ್ಗಡೆ ಟ್ರಾನ್ಸ್ಪೋರ್ಟ್, ಈ ಕಡೆ ನಾನ್ ಟ್ರಾನ್ಸ್ಪೋರ್ಟ್, ಆ ಕಡೆ ಟ್ರಾನ್ಸ್ಪೋರ್ಟ್.
Transport.
TR ಟ್ರಾನ್ಸ್ಪೋರ್ಟ್ 2016 ತಗೊಂಡಿದ್ದಾನು.
17-10-2019 to 16-10-2024.
ಹೌದು ಹೌದು.
ಆಕ್ಸಿಡೆಂಟ್ ಆಗಿದ್ದು 18 ಅಲ್ಲಿ. ಬಿಫೋರ್ 19 ಲಿಂದ ತಗೊಂಡಿದ್ದಾರೆ. 18 ಆಗಿದೆ. 18.
16 ತಗೊಂಡಾಗ ಅಪ್ ಟು 3 years ಕವರ್ ಆಗುತ್ತೆ ಸ್ವಾಮಿ.
14-4-2018.
ಹೌದು.
14-4-2018 is the date of accident. Please ma'am. ಎಲ್ಲಿದೆ?
16 ತಗೊಂಡ ಮೇಲೆ ದಟ್ ವಿಲ್ ಕವರ್ ಅಪ್ ಟು 3 years ಮಾಡೋಣ. 16 DL ತಗೊಂಡ ಮೇಲೆ 17, 18, 19 ಮತ್ತೆ 19ರಲ್ಲಿ ರಿನ್ಯೂವಲ್ ಆಗಿದೆ.
ಸರ್ DL for what?
ಫಾರ್ ಟ್ರಾನ್ಸ್ಪೋರ್ಟ್. ಅಲ್ಲಿ ಮೇಲ್ಗಡೆ ಅದನ್ನೇ ತೋರಿಸ್ತದೆ. ಆ ಬಾಕ್ಸ್ ಮೇಲ್ಗಡೆ ಸ್ವಾಮಿ 2 ಕಾಲಮ್ ಇದೆ. ಒಂದು ಟ್ರಾನ್ಸ್ಪೋರ್ಟ್ ಅಂಡ್ ಒಂದು ನಾನ್ ಟ್ರಾನ್ಸ್ಪೋರ್ಟ್ ಅಂತೇಳಿ TR ಅಂತ ಬರ್ದಿದ್ದಾರೆ. ಆ 16 ಮೇಲ್ಗಡೆ ಹೋದ್ರೆ ಹಂಗೆ ಸ್ವಾಮಿ TR ಅಂತ ಬರ್ದಿದ್ದಾರೆ. ಆ ಬಾಕ್ಸ್ ನಲ್ಲಿ ಬಾಕ್ಸ್ ಹೆಡ್ಡಿಂಗ್ ಬಾಕ್ಸ್ ಸ್ಟಾರ್ಟ್ ಆಗುತ್ತಲ್ಲ ಸ್ವಾಮಿ, ಮೇಲೆ ಟ್ರಾನ್ಸ್ಫರ್ TR ಅಂತ ಬರ್ದೈತೆ. ಅದು ಐ ವಿಲ್ ಮಾರ್ಕ್ ಇಟ್.
Sir, the original DL was given for what?
First, but any time always LMV. Thereafter
LMV date of issue 5/9/2012.
12, please. For 20 years, 32 years.
ಆಯ್ತು.
For transport, a TR ಅಂತ ಬರ್ತೈತೆ. ಅದಕ್ಕೆ for transport, for transport TR ಅಂತ ಬರ್ತೈತೆ ಮೇಲ್ ಹೆಡ್ಡಿಂಗ್. ಅದು 16ರಲ್ಲಿ ಶುರು ಮಾಡಿದ್ದಾರೆ.
ಇಲ್ಲ.
ಇವಾಗ ವಾಟ್ಸ್ಆಪ್ ಶುರು ಕೊಟ್ಟಿಸ್ ಮಾಡಿ 13ಕ್ಕೆ ಮಾಡಿದ್ರು, ಆಮೇಲೆ 16ಕ್ಕೆ ಮಾಡಿದ್ರು. 13 ರಿನ್ಯೂವಲ್ ಟ್ರಾನ್ಸ್ಪೋರ್ಟ್ 2013. 3 ವರ್ಷಕ್ಕೆ ಮುಗಿದೋಗುತ್ತೆ. 16ಕ್ಕೆ it was renewed. That is up to 2019. 16ಕ್ಕೆ ಡೇಟ್ ಇದೆ ಸ್ವಾಮಿ. ಪೆನ್ನಿಂಗ್ ಮಾರ್ಕ್ ಮಾಡಿದ್ರಲ್ಲ, that is up to 16. ಅದೇ ಲೈನ್ ಮೇಲ್ಗಡೆ ಬಂದ್ರೆ TR ಅಂತೀವಿ. ಅದೇ ಮೇಲ್ಗಡೆ ಅದೇ TR ಟ್ರಾನ್ಸ್ಪೋರ್ಟ್ ಇರೋದು. ಅಂದ್ರೆ ಮೇಲ್ಗಡೆ 13 ಅಂತಿದೆ ಸ್ವಾಮಿ. 14 ಮೇಲ್ಗಡೆ 16 ಅಂತಿದೆ. ಸಾರಿ 13 ಇದೆ. 13ರಿಂದ 16 16ರಿಂದ 19
Anyway, this is something that we are required to consider after examining the records.
Please, if your lordship is in, he was seeking interim order. If seeking interim order, that amount I am permitted to do, because secondly, either owner is liable, pay and recovery. Either even though having a document, I am entitled. On 2 way I will enter. That is may permitted to withdraw that amount.
Who is respondent number 7?
He is the owner of the vehicle.
Owner of the vehicle, please.
Served agide.
So on that ground, you are also saying a liability.
Yes, ma'am. Only at one point is he is only having only one ground in the whole appeal.
ಇದಾಗಿದೆ ನೋಟಿಸ್ ಇಶ್ಯೂ ಆಗಿದೆಯಾ?
ಆಗಿದೆ ಸ್ವಾಮಿ.
ಎಲ್ಲರೂ ಅಪೇರ್ ಆಗಿದ್ದಾರೆ.
ಆಗಿದೆ.
1 to 6 malad he was appearing claimants. R7 notice was served. ಇದು stay you did not
Earlier ಕೊಟ್ಟಿಲ್ಲ ಸ್ವಾಮಿ.
earlier delay is there. Therefore this honorable court malad issued notice malad one.
Even I will appeal.
ಇಲ್ಲ ಹಾಕಿಲ್ಲ ಸ್ವಾಮಿ. ಆಕ್ಚುಲಿ ಈಗ ಇದು ಅಡ್ಮಿಟ್ ಅದ ನಾನು ಹಾಕ್ತೀನಿ ಕ್ರಾಸ್ ಅಪೀಲ್. ಐ ವಿಲ್ ಕಮ್ ಇಟ್ malad. If appeal is admitted, I will come with a cross appeal.
Order on IN number 1 of 2023. There is a delay of 88 days in filing the appeal. Full stop. Having regard to the grounds raised in the appeal at the hands of the appellant insurance company, that The tribunal accepted your contention, is it?
No. Accepted our contention and distinguished that their evidence, he was in having a DL ಅಂತ ಹೇಳಿ. He was having a transport DL ಅಂತ ಹೇಳಿ hold ಮಾಡಿದ್ದಾರೆ. And not only
The tribunal was observing that, my lord, he was taken DL from, obtained DL from 2012 up to 32.
ಏನ್ ಹೇಳಿದೆ?
There is a delay of 88 days in filing the appeal, having regard to the grounds raised in the appeal at the hands of the appellant insurance company.
That the tribunal has erred in not accepting the contention of the insurance company that as on the date of the accident, that is 14/4/2018, there was no valid driving license for the driver of the vehicle to drive a transport vehicle. Bracket ali heavy goods vehicle. The tribunal has brushed aside the said argument. A prima facie case has been made out by the appellants. Stop. Therefore, we proceed to condone delay of 88 days in filing the appeal. Stop. However, with the condition that the appellant shall deposit 50% of the award amount before the tribunal within a period of 6 weeks from today. Full stop. We are also inclined to accept the submission of the learned counsel for the respondent claimants that at any rate the appellant may have to deposit the award amount even on the ground of pay and recover, we direct the appellants to deposit 50% of the award amount before the tribunal, and the claimants are permitted to seek withdrawal of the said amount. Much.
Case number 17, government advocate.
This matter may be posted on 27th, my lord. The other matters are lordship posted this one, my lord. Learned AC will argue this one.
290 days delay.
Yes, my lord, that is my behind 120 days delay, my lord, please.
Ade. So 27th, huh? Notice issue agide agale? Illa, caveat.
They are already represented, my lord. Caveat is filed, my lord, that is returned, my lord, will also take, direct him to take notice.
Karaddi has entered appearance for
All respondents.
R1, R2 and R4. Caveat they have filed.
respondents number
R1, R2
and 4. 1, 2 and 4. Issue notice to respond number 3. Release this matter on 27th of November. Yes.
Case number 18, Babu H. Metagudda.
Delay up to 29 days in filing this appeal, my lord. Case of injury, my lord, other connected matters are pending, my lord.
Notice order ಆಗಿದೆಯಾ?
Lordship.
Notice order ಆಗಿತ್ತು.
ಒನ್ನಿಗೆ ಆಗಿಲ್ಲ ಸ್ವಾಮಿ, ಒನ್ನಿಗೆ dispensation memo ಹಾಕ್ತೀನಿ.
ಅಲ್ಲ ನಾಟ್ ಆರ್ಡರ್ಡ್ ಅಂತಿದೆ, ಬಟ್ ನೀವು ನಾಗ್ಲೇ ವಕಾಲತ್ ಫೈಲ್ ಮಾಡಿದೀರಾ?
ಹಾ ಮೇಡಮ್, ಟೇಕ್ ನೋಟಿಸ್ ಅಂತ ಮಾಡಿದಾರೆ ಸ್ವಾಮಿ, R1 ನೋಟಿಸ್ ಆರ್ಡರ್ ಆಗಿಲ್ಲ.
ಆ ಟೇಕ್ ನೋಟಿಸ್ ಅಂತ ಆಗಿದೆ ಅವ್ರಿಗೆ R1 ನೋಟಿಸ್ ಆಗಿಲ್ಲ ಸ್ವಾಮಿ ಅವತ್ತು ಬೈ ಮಿಸ್ಟೇಕ್ ಡಿಸ್ಪೆನ್ಸ್ ಮಾಡ್ಬೋದು ಸ್ವಾಮಿ ಮೆಮೋ ಫೈಲ್
You are filing memo.
ಮೆಮೋ
Learned Counsel Shri Manavendra Reddy has entered appearance for respondent number 2. You have a copy of the appeal memo?
ಎಸ್ ಸರ್ವ್ ಮಾಡಿದ್ದೀನಿ
Learned Counsel for the appellant has filed a memo seeking dispensation of notice to respondent number 1 on the ground that respondent number 1 is the owner of the vehicle and the liability has been fastened on respondent number 2 insurance company. Full stop. Next para. At the risk of the appellant, notice to respondent number 1 is dispensed. Next. Order on IA number 1 of 2023. Delay of 229 days in filing the appeal is condoned on condition that the appellant shall not be entitled for payment of interest during the delayed period. Yes.
Connect.
List this matter along with. I'll put it.
Seal number 19, Vishal Pratap Singh.
There is a delay, my lords, in filing the appeal. My prayer is to condone the delay, my lords.
Appeal by accused.
Appeal by the accused, my lords. He is a convict.
Order on IA number 1 of 2024. Having regard to the fact that the appellant has been convicted under section 302 of the IPC to undergo a rigorous imprisonment for life, we condone delay of 115 days in filing the appeal.
Delay may be condoned, let them file objection for my IA2.
Next para. A week's time is granted.
2 weeks.
2 weeks time is granted at the request of first learned additional SPP takes notice for
Yes.
the respondent state.
Yes.
At the request of learned additional SPP, 2 weeks are granted to file objections to IA number 2 of 2024.
Please.
Yes.
Grateful minutes.
Seal number 20, K. Ravindra.
I'm challenging the order.
My lord, it
Rejecting
is
my
posted
application
for
before
orders
the
today.
administrative
Kindly
tribunal.
be posted for preliminary hearing, my lord. Will, yesterday they are served copy and the caveator. It is listed for orders, my lord. And it may be posted for
Let me-
preliminary
let-
hearing on any
I
day, my
just-
lord, will argue.
May I seek permission? Let me place my submissions on record. He may take time my lords, after what I submit. My lords, this is a case of a premature transfer of the petitioner
My lord.
and posting of the respondent number 2 at the place which was held by the petitioner.
But sorry for
My
the
lords, we
interruption,
see
my
that
lord.
on
Very sorry, my
6/7/2023,
lord. In this matter, my lord, additional advocate general my lord wants to argue this matter. Kindly pass over this matter for some moment.
Allala, the learned counsel for respondent number 2 is also asking for matter to be listed for preliminary hearing.
Yes, my lord, no problem.
We will see if required, we will adjourn the matter. Yes.
Please.
lords, the petitioner firstly is appointed as Assistant Commissioner Raichur on 6/7/2023. And she reported to a duty or joined that Raichur on 7/7/2023. Due to the elections for Lok Sabha, by an order dated 1/2/2024, she was required to be working as at Chikkodi, where the direction was to report back to Raichur after the elections are over. The persons are not permitted to work in the hometown is what the reason was given. So, my lords, on 11/6/2024, the petitioner reports back to Raichur again as Assistant Commissioner. On 13/9/2024, the orders at Annexure A3 and A4 are passed.
What date?
13/9/2024. Orders at Annexure A3 and A4 are passed, which are at page numbers 58 and 59. By virtue of annexure A3 58, the Under Secretary passes this order posting this petitioner, who is at serial number 1 at Bangalore. And my lords, kindly see this. I will read this preamble to that. It says, ಈ ಕೆಳಕಂಡ KAS ಕಿರಿಯ ಶ್ರೇಣಿ ವೃಂದದ ಅಧಿಕಾರಿಗಳನ್ನು ಸಾರ್ವಜನಿಕ ಹಾಗೂ ಆಡಳಿತಾತ್ಮಕ ಹಿತದೃಷ್ಟಿಯಿಂದ ಮತ್ತು ಸರ್ಕಾರಿ ಆದೇಶ ಸಂಖ್ಯೆ ಸೋ ದಿನಾಂಕ 25/6/2024 ಕ್ರಮ ಸಂಖ್ಯೆ 5-2 ಅನ್ವಯ ತಕ್ಷಣದಿಂದ ಜಾರಿಗೆ ಬರುವಂತೆ ಹಾಗೂ ಮುಂದಿನ ಆದೇಶದವರೆಗೆ ಅವರುಗಳ ಹೆಸರಿನ ಮುಂದೆ ನಮೂದಿಸಿರುವ ಹುದ್ದೆಗಳಿಗೆ ವರ್ಗಾಯಿಸಿ ಆದೇಶಿಸಿದೆ. So they are saying that my transfer is under rule clause 5, subclause 2 of the guidelines, transfer guidelines, which are at annexure E. Now the next page, page number 59. This doesn't say it is under rule 5, clause 5 or 6 or anything. This is a notification by the Deputy Secretary of the government. And at number 3, the third unnumbered paragraph is respond number 2. Herein, Sri so and so, IAS 2022, waiting for posting is posted with immediate effect and until further orders as Assistant Commissioner Raichur. That is the post which is held by the petitioner as on this date. Now, my lords will kindly permit me to show to your lordships page number 63 of this paper book, paragraph 6 of the statement of objections which are filed by the state.
Page number?
Page 63. This is internal page 3 of the statement of objection of the state. Para 6, my lords will see. It is submitted that the respondent number 2 is not a probationer. Kindly mark this one. He is an officer of Indian Administrative Service, IAS of 2022 batch. The officer was given posting as Assistant Secretary in Ministry of MSME, Government of India in New Delhi from 20th of May 2024 to 12/7/2024. After the completion of the central service, the officer has reported to the state government for posting on 5/9/2024. I will stop here, my lords. The rest of the portion are also relevant. It should not mean that I am suppressing something. I will read all that. Just to drive my point home. The argument before the tribunal and in the statement is that under 5.2.53 of clause 5.3, if a first posting is to be given to somebody, a direct recruitee, then that will be an exception to clause 6. Clause 6 is my protection of the tenure of 2 years as a class 1 officer. Clause 5, subrule 2, they argue is an exception to clause 6. And it is the first posting of a direct recruitee, which is permissible under clause 5.2. They do not invoke clause 5.2 at annexure A4, page 59. Nonetheless, my lords, factually also, this is not the first posting of that officer. He might be getting posted for the first time in Karnataka. That cannot be treated as the first posting of the officer. The word used in clause 5.2 is first posting of that officer, not first posting by the government. So he is already posted at some place. This will be subsequent posting only. So factually 5.2 is not applicable. Legally also 5.2 will not be applicable. Even in annexure A4, page number 54, my lords will say they have not invoked section clause 5.2 of the guidelines. For transferring me at annexure A3, they are invoking 5.2, which is even otherwise not applicable to me. I am not a person who can be transferred under 5.2. I can be only transferred under rules clause 7. Clause 7 is the exception to reduce the tenure of the minimum tenure. So, my lords, the entire action seems to be completely, I can only say, my lords, not only erroneous, but also with legal malice. The tribunal, my lords, holds that these guidelines at annexure E, 2024 guidelines, paragraph number 12 of the order impugned at page 26, my lords will. It says, my lords, having heard the government and aforesaid submission, we arrive at following conclusion. Page 26, paragraph 12 of the order impugned. One, the transfer guidelines 2024 has replaced the earlier guidelines 2013 and revised instructions have been issued. Clause 6 of the guidelines makes it clear that minimum period of stay for Group A officer at a place is 2 years and no government servant shall be generally be transferred if he has not completed 2 years of tenure. It is further stated in clause 5 that with prior approval of the Honorable Chief Minister,
Group A officer.
Group A office, assistant, approval of Honorable Chief Minister in respect of certain persons, the person can be posted to certain posts beyond general transfer if a direct recruit are to be posted on their first appointment. Applicant is governed by the said transfer guidelines, and the grievance is that while transferring the applicant to the vacant post of Assistant Commissioner KSHP, the applicant is transferred prematurely before completion of 2 years tenure. It is clearly evident from the records on hand, and in particular Annexure R3, appended with statement of objections, that order of transfer has been effected with prior approval of the Honorable Chief Minister. As such, it cannot be said that the order of transfer is in violation of transfer guideline. I will show to your lordships Annexure A3 also, Annexure R3, which is the note of the officer and then signed by the Honorable Chief Minister, saying that there are rules which permit transfer, and that is with regard to transfer of the respondent number 2. And then, my lords, the name of this petitioner is also added there. Applicant has not made out any ground. Annexure R3, my lord. Annexure R3. That is at page number 74.
That new 24 guidelines.
Annexure E, page 86 onwards. This requires some interpretation. Was in fact a division bench of this honorable court, headed by His Lordship Justice, the Chief Justice, has also, my lords, interpreted these rules and has stated that. Anyway, I will read to your lordships, my lords, the relevant provisions. Kindly come to page 86, the explanation clause, clause 2. Competent authority means appointing authority or such other authority authorized to make transfer or deployment. Then transfer and deployment are the definitions which may not be required now. Then number 3, clause number 3, process of transfers or deployment shall be made by the competent authority subject to the conditions stipulated in this order, mainly in the interest of public service in a transparent manner. 4, restrictions on transfers and responsibilities of competent authorities and government servants. 1, ministers in charge of the respective departments are hereby delegated the power to make general transfers from 25/6/2024 to 9/7/2024. I am emphasizing this, my lords, because it is defined in this guideline that from period from 25/6/2024 to 9/7/2024 is also treated as general transfer duration. I will skip the other portion of this clause 4 months. It may not be relevant for that. If your lordships want me to read it, I will read it. It may not. Then kindly come to clause 5 in the next page, page 88. Transfer should not be made beyond the period of general transfers, except in the following circumstances. Now, my respectful submission is, before I read the entire content of this clause, this is an enabling provision to say that general transfer is the rule. Beyond general transfers, you can do it. This is just giving a power to the government to say that this, as an exception, you can do it. What are the exceptions are carved out? Where transfer or deployment of a government servant is considered instead of placing him under suspension. 2, where new offices or posts are created or posts have become vacant due to retirement, promotion, resignation, reversion, dismissal, death, compulsory retirement. Next or when direct recruits are to be posted on their first appointment. This is the clause which they want to apply here. Or promotees are to be posted on promotion or due to any unforeseen circumstances, and when the posts are required to be filled immediately. So this enables the government to make a transfer beyond the general transfer period. This is only that one. Now, this cannot be read in isolation. In fact, the state government in its objection is also saying the same thing, that rule clause 5 cannot be read in isolation. Now, my lords, I will skip the other part of this clause 5. Clause 6 is relevant for my argument. Minimum period of stay at a place.
There is no dispute about
There is no dispute about it. Then clause 7.
Only the interpretation of when direct recruits are to be posted on their first appointment.
My respectful
This is the only.
yes, yes. Now, not that one. That clause only says, yes, after general transfers duration period, you can transfer somebody if these three conditions are fulfilled.
Yes.
Direct promotees, direct recruits, or new offices are created. That is enabling provisions. But is it to be read contrary to rule clause 7? So clause 7 speaks this. Clause 7 says premature or delayed transfers. The minimum period of service which a government servants may render at a place may be extended or reduced in the following circumstances. A government servant who has completed the maximum period of stay at a place and due for transfer has less than 2 years of service for retirement. That person can be continued. If a government servant possesses special technical qualification or experience and no suitable government servant is immediately available for being appointed to such a specific post to replace him. This is also not the case. Annexure R3, the approval of the chief minister doesn't say that this person is having.
See, this will not come into operation. What this provision says is the minimum period of service which a government servant may render at a place may be extended.
Yes, or it can be reduced.
Or reduced. So, there is a provision for reduction also.
Yes, yes, reduction also.
Yes.
This is what they should in fact use. They cannot only harp upon 5 is what. Reduction is also permissible here. Then C, where an employee is working in a central government project or a flagship project, the implementation of which is at an important stage and withdrawal of his services is likely to seriously stall timely completion of that project. Then he can be continued there, or where both the spouses are government servants and if one of the spouses is transferred, then the other spouse may also be transferred to the same place or nearby place.
Our contention is a statement has to be made in the order of transfer, meeting the requirement of clause 7.
Great.
Is your contention?
Grateful. Great. Clause 5 cannot be independently utilized, especially in a case where if it was already a vacant place, my lords, then after the general transfer period, some person direct recruitee can be posted there. Clause 5 can be invoked in that circumstance. But if somebody who is already holding a post to disturb him prematurely would have to there, my lords, only clause 5 cannot be made up. Clause 7 is mandatory. And this is, my lords, held by a larger bench of this honorable court and consistently held by several courts, several judgments, that these have the force of law and they are mandatory in nature also. In fact, my lords will see the judgment of this honorable court, referring to in the case of K.S. Sudhakar versus the state of Karnataka. This was subject matter of the discussion before the tribunal also, my lords. It was a part of the statement filed by the state also.
Submission.
May I read from, my lords, paragraph 17? Before that, my lords, the rules are mentioned, relevant clauses are extracted. Analysis starts from para 11. Analysis starts from para 11. But then, my lords, shall I read from para 11 for the purpose of clarity?
Only that
relevant portion would be from para 17. The comprehensive reading of transfer guidelines 2024, it regulates the transfer of government servants even as deployment. It is difficult to accept that transfer guidelines 24 ought not be applicable to deployment. It is right law that the explanation cannot be used as an interpretation tool to understand the scope and ambit of the substantive law. If the explanation is to be given preference to interpret the transfer guidelines 2024, it would act as an exception to the substantive law, which is not the scope of explanation. Explanation in no way explains the substantive law, however, runs contrary to the substantive law. Clause 6 of the guidelines provides for a minimum tenure of posting to a government servant at a place. The minimum period of tenure varies to different groups of officers. This court is concerned with Group B officers. The minimum period of tenure at a place for Group B officers is 2 years. Clause 7 of the transfer guidelines 2024 enables premature or delayed transfers. In other words, clause 7 would be an exception to clause 6. Clause 7 empowers the government to extend or reduce the period of posting at a place to the government servant, however, in the circumstances provided therein. Respondent number 3 was transferred to the regional office, Sarjapur, Bangalore, as environmental officer under office memorandum dated 6/3/2023. As per clause 6 of the transfer guidelines 2024, respondent number 3 has the protection of a minimum posting period at a place for 2 years. There is no dispute that the appellant and respondent number 3 are Group B officers. It is not in dispute that no reasons have been recorded for premature transfer of respondent number 3. Respondent number 1 and 2 have neither placed any material nor content that the premature transfer of respondent number 3 is in circumstances contemplated under clause 7 of the transfer guidelines 2024. It is the categorical statement of the learned advocate appearing for respondent number 2 that no reasons are being recorded. The learned advocate for the appellant would submit that posting a government servant from one office to another within the same headquarters in an urban area is not a transfer and is deployment. He submits that as per the explanation in Kannada version, transfer guidelines 2024 are made inapplicable to deployment. Transfer guidelines are not applicable in the present case. Submission of the government learned advocate for the appellant is appealable at the first blush. However, it is difficult to accept contention on examination of the transfer guidelines 2024 to the fullest extent. The transfer guidelines 2024 provides a minimum period of tenure at a place to a government servant in case of transfer or deployment. The office memorandum dated 15/7/2024 refers to transfer of officers. Impugned office memorandum posting respondent number 3 from regional office to head office states ordered to be transferred details of posting. Contention regarding the case of deployment is untraceable. As per clause 3 of the transfer guidelines 2023, transfer process including the deployment is mandated subject to conditions stipulated in the transfer guidelines 2024 and on consideration of the interest of public servants and in a transparent manner. Clause 3 mandates the applicability of transfer conditions in case of deployment. Even if the contention of the appellant that it is the case of deployment is tested having regard to the guidelines, as per clause 6 of transfer guidelines 2024, respondent number 3 is entitled to a minimum tenure posting at a place for 2 years. Respondent number 3 was transferred as environmental officer to the regional officer Sarjapur, Bengaluru by office memorandum dated 6/3/2023. Further transfer under office memorandum dated 15/7/2024 would abbreviate the minimum posting period of 2 years and is nothing but premature transfer in violation of transfer guidelines 2024. Clause 7 of the transfer guidelines 2024 enables premature or delayed transfers. Clause 7 is an exception to clause 6 of transfer guidelines 2024. However, clause 7 enables the government to extend or reduce the posting period to a government servant at a place subject to the circumstances stated therein. On a conjoint reading of clause 6 and 7, it is clear that the government servant is protected with a minimum period of tenure at a place, and the same can be reduced only under the circumstances provided under clause 7. Another aspect needs to be noticed and relevant is similar situation was provided in the government order dated 7/6/2013. Clause 3D of the government order dated 7/6/2013 defines transfer and follows a note to the definition of transfer. The same reads as under. Note is movement of a government servant. That was for the purpose of the note to
The contention that you are now seeking to make
yes
is not what is considered here. We'll have to consider that afresh.
Great. My respectful submission is, my lords, what has been very categorically upheld by the Honorable Division Bench is Rule 6 is the rule. It's a mandate that there is a protection of the tenure. Rule 7 is only the exception. Now, Rule 5 cannot be, my lords, read in isolation. There cannot be two rules impacting the very same transfers of an employee.
Then what is the intention of the insert of the Rule 5, my lord? And moreover, I'll make only one submission, my lord. After transferring, my lord, to the petitioner, now she is also taken the charge before wherever she is transferred, my lord. Since from 2 months, she is also working in Bangalore, my lord. Even in spouse cases also, respondent number 2 and his husband, wife is also working in Raichur. And petitioner husband is also working in.
Or if that was the reason for posting, that should have been stated.
Please, my lord.
That is not stated.
And kindly see it is required for some consideration. I'll make a detailed submission, my lord. Before the tribunal, I have relied certain judgments, my lord. ಈಗ ನಿನ್ನೆ ರಾತ್ರಿ ಕಾಪಿ ಸರ್ವ್ ಮಾಡೋದ್ರಿಂದ today I am unable to make submission, my lord. Kindly it may posted for plenary hearing any day. It required some
Monday.
Kindly see page number 10. There's only one. True, my lord. Kindly see page number 10 was only one statement which I made in the petition. It says this Roman number 8 in page 10 in my petition. It is submitted that the respondent number 2 forcibly took charge from the petitioner on 13/9/2024 at about 10:30 a.m. Now, my lords, I have to also follow the discipline.
It is also good that you took charge there because we have frowned upon officers who do not take charge. We said your first duty is to go and take charge.
And then challenge.
That itself will not
That-
preclude you from pressing the
Grateful.
prayers made before the court.
I'm grateful.
Yeah,
That was my argument only. Just because I have taken charge, I have followed the discipline which
That
is mandated.
that
Please.
cannot be accepted. At the request of learned government advocate and learned counsel for the respondent, caveat respondent, release this matter on 25th of November for preliminary hearing.
Great. Great. No, I may be permitted to appear online, no, there is some.
Or you want it on Tuesday, you can have it on Tuesday.
On 25th, I'm available, no, but I will not be at this place, so I will come online. That will be.
No, you want on 26th?
26 and 27 also, I'm out of station.
All.
Great.
CL number 21, Chaitanya Kumar Chandra.
My lord, I am for complainant. There was a direction issued against respondent 3 and 5 to consider my representation and cause Podi and Durasti work in respect of my survey number, my lord. In spite of making representation, the Tahsildar is not generating any ROR and causing Podi.
Learned government advocate takes notice for respondent number 3. Learned counsel for the complainant is directed to serve copies of the petition along with annexures of the learned government advocate.
Please.
Sir, issue notice to response number 1 and 2 returnable by 5th of December.
Please.
CL number 22, GG Chakshetty.
Not I beg to appear for the petition, please. Please, the petition is directed against the orders of the Honorable KCT, dated 19/9/2024, page number 19, Lord, annexure E. Lord, the content proceedings is dropped on the ground that the orders of this Honorable Court has been duly complied with. Lord, the initially was pursuant to the orders of this Honorable Court. I was appointed, Lord, the relevant portion of the orders of this Honorable Court, which where they have challenged the KAT order as reads as under, please. Page number. Annexure A1, your lordship may kindly see, annexure A1, page 42, the operative portion is at page number 50.
Dropping of the contempt proceedings. Huh?
How so? Drop money, contempt proceeding drop.
Is what you're questioning here.
My dropping the contempt proceedings, the order is not at all complied with.
No. Is there any interim prayer from your side?
Interim prayer not carried, sir. Interim prayer. Only one submission. Lord may kindly refer to page number 50.
Not necessary, sir. We'll have to issue notice to the other side. We'll issue.
Grateful. What I'm telling you, the honorable tribunal has scant regard for the orders of this honorable court. Page number 50, you will also be kindly one minute, please. That's all.
Takes notice for both the respondents. Learned counsel for petitioner is directed to serve copies of the writ petition along the annexures on the learned government advocate. Yes.
Admission matter CL number 23, Manvendra Reddy.
Great.
An appeal filed with insurance company challenging liability.
Insurance company.
Admittedly, there are two motorcycles were involved.
Liability, na? Liability or contributing negligence?
Liability and contributing negligence.
Contributing negligence only. Notice ತಗೊಂಡಿದ್ದೀರಾ ಆಗ್ಲೇ? Admit. Call for trial court records.
Charge sheet our ಮೇಲೆ ಇದೆ sir.
Other if the contention is that we are not liable, can we consider the appeal without looking into the records? Not possible. Yes.
CL number 25, question daily.
Accused my lord. Lord, now he has been convicted under section 4 of the POCSO Act. The respondent number 2 is the father of the victim girl. Notice has to be.
Learned additional SPP. takes notice for respond number 1. Issue notice to respond number 2. Huh?
He has been sentenced to life imprisonment, my lord. Matter may be admitted, my lord.
Admit. Call for trial court.
LCR,
Yes.
please.
CL number 26, Rajesh Gaddamani.
Matter is called out. There is no representation for either of the parties. Release this matter on 5th of December.
CL number 27, B group matters, SS Mohammadapur.
Raise for time.
At the request of learned counsel for the petitioner, release this matter
1 week.
on 2nd of December.
Please.
CL number 29, Villappa Yerur.
Matter is called out. There is no representation for the petitioner. For either of the parties. Release this matter on 2nd of December.
CL number 30, 30, Rabindra Reddy.
Same order.
2nd of issue.
3rd of December.
Sir.